All right, please be seated. All right, and are you juror 414?
I am.
All right, then I'll allow the attorneys to begin their inquiry.
Good afternoon. I'm Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to coming in today for your jury service, did you know anything about this case?
I do, yes. I heard about it in 2019 when it happened.
Okay.
Yes.
Have you followed the case since 2019?
Here and there, yeah. I have some friends from Tallahassee, so we've talked about it in the past, certainly.
And based on what you've heard or seen, do you already have a fixed opinion about the case, or would you be able to put what you've heard aside and listen only to the evidence in this courtroom?
I do have an opinion, yeah.
All right, thank you.
I have no question, Judge.
All right, sir. Your jury service is complete for the year, and you're excused. Thank you.
This way, sir.
Yeah. All right. Any objection to 414 being checked for cause?
So, Your Honor.
State.
We are 36. He indicated he knew somebody.
Okay.
One person.
Because everybody probably knows.
Who is it?
Oh, no. Okay.
All right, please be seated. Are you jury 36?
Yes, sir.
All right, I'll allow the attorneys to begin their inquiry.
Good afternoon.
Good afternoon.
How are you today, sir?
Doing pretty good, thank you.
Do you know, I know you said you know people, do you know probably most of the people in this courtroom?
Yes, I do.
And where do you work?
Was a probation officer for about 18 years, and the last 2 years was a pretrial officer.
Okay. And are you still working in pretrial services?
Yes, I am.
Right. Do you know anything about this case that we're here for today?
I do not.
All right. Based on where you work and what you do, would you be able to sit on this case and be fair and impartial?
Yes,
All right. So I'm going to start with pretrial publicity then. Have you heard anything about this case on the news?
I have not.
So, and then as far as the length of the trial, I assume that your employer will let you be here and serve as a juror.
They will.
Okay. I want to move on to the issue of the death penalty. Do you have any personal or moral or religious opposition to the death penalty?
I don't.
Let me ask you just as far as where you may fall with regard to your opinion on the death penalty. We have some people that are on one side of the spectrum that would say that they think anybody who's charged with first-degree murder should get the death sentence, regardless of the facts, regardless of the circumstances. They just think it's an automatic death sentence. Then you have people on the other side that would say no one should ever get the death penalty, no matter how heinous the crime, no matter how many people are killed, we shouldn't even have it. Then you have people that are in the middle that would say I would have to hear the facts and the circumstances in the case in order to make up my mind. Where would you say you fall on that spectrum?
I would say in the middle.
Now, you're probably somewhat familiar with the jury process because of what you do, but the first phase will be the guilt phase where we have to prove the charges beyond a reasonable doubt. And then we'll go to the penalty phase where we will have to prove, and we go to the penalty phase if the jurors unanimously decide the state has proved its burden and proved at least one charge beyond a reasonable doubt of first-degree murder. Then at that penalty phase, the state has to prove an aggravator. And we have listed aggravating factors that we believe this case that we can prove beyond a reasonable doubt. At that point, all the jurors have to find unanimously that we have proven one count beyond a reasonable doubt or one aggravating factor. The defense also has the opportunity to present mitigating circumstances and to give reasons as to why their client should not get the death penalty. And then at the end, it will be up to you as a juror to make a recommendation of either life or death. Do you believe you'd be able to make a recommendation of death if the facts and circumstances fit that?
I think I would.
Okay. And what about for life? Do you think you'd be able to make a recommendation of that?
Yes.
Now, obviously, you work in the courthouse. You probably know a lot of people. I assume you know a lot of bailiffs, probably law enforcement, just people in all the departments in the courthouse. Would, if you were to say that, I don't think the state really gave enough or gave the right facts or circumstances for me to believe that the defendant should be given the death penalty, would that be something that you would be embarrassed about, or that would be hard for you to tell your coworkers or friends that, nope, I chose life?
Again, I would have to just listen to all the facts
Sure.
to know the state is going to do the state job.
Okay.
It would not be embarrassed for me if they do the job or not.
Okay, right. So you don't feel some strong connection to the state. You're here as a juror, and you don't feel that you owe it to us to make a certain finding. Would that be fair?
That is correct. And with my job, again, sometimes as a probation officer, I have certain feelings, and the state might do something different because I know they're doing the job.
Sure. So you would say, and that's a good thing to bring up, as a probation officer, you often had to make recommendations of a sentence, and sometimes the state would want something higher. Is that accurate?
Or lower.
Or lower, right? And so you had to be able to justify your opinion and what you thought in front of the court.
That's correct.
Right. And so you would feel comfortable then, in this case, to justify your own opinion based on your own experiences and based on what you hear in court.
That's correct.
All right. Thank you for your time.
All right, Mr. Shirley.
No question.
All right.
No question.
No question.
Okay. So you remember my instructions about not doing any research, looking up anything, or discussing anything about this case with anyone. You remember all that?
Yes, sir.
All right. Can you follow those instructions?
Yes, Your Honor.
Also, do not look up anything on the internet regarding the case. Don't watch local news media or read local newspapers. Can you refrain from doing those things?
Yes, Your Honor.
All right. Then follow those instructions, and we'll see you tomorrow morning at 9 a.m. in the jury room on the second floor. All right.
Thank you, Your Honor.
All right. So now we've got 382.
Sure entrance.
All right. Please be seated. Are you juror 382?
Yes.
All right. I'll allow the attorneys to begin the inquiry.
Good afternoon. How are you?
Good.
I'm Sarah Miller. This is Andreas Gardner, and we're both here on behalf of the state. Prior to coming in today, had you heard anything about this case?
I have.
And where have you heard information?
Online, through the news, things like that, Facebook, social media.
All right.
I don't remember much, but
Sure, just bits and pieces throughout the course of this case.
yes.
Now, the state has an obligation to prove the charges beyond a reasonable doubt, and we do that by presenting evidence in court. And we can't control what happens in the media or what's put out or what's not put out. Some of what you see in here may be true, some may not, some may be admissible in court, some may not. Would you be able to set aside what you've heard or seen or read and base your opinion solely on the evidence you hear in court?
I think I could do a pretty decent job doing that.
Okay, so you didn't come into court with your mind made up about whether the defendant's guilty or not.
I mean, there are some biases there, a little bit, I would say so.
Okay. Do you think that, and of course, when you read an article or see something, you're going to have an opinion. I mean, that's just a normal thing. Would you be able to put those opinions aside and what you've seen and start fresh and be able to hold the state to its burden to prove the charges?
I believe I could do that, yes.
Now, looking at
I'm sorry, what did you say? I didn't hear you.
I believe I could do that, yes.
looking at the length of the trial, it's expected to be 3 weeks total, so probably another 2 weeks. Do you have anything coming up in the next 2 weeks that will cause issues for you to sit here on this jury?
I am going out of town at the end of June for about 4 days or so. And that's about it. I do have an elderly relative that depends on me to go to work and pay bills and things like that.
Depends on you to what? I'm sorry.
Depends on me to be at work pretty consistently and get paychecks and stuff like that.
Sure. Where do you work?
A senior living facility in Fort Myers.
Okay. If you were to not work for 2 weeks, would that cause you to not be able to pay those bills?
I believe so, yes.
And because of that, would you have a difficult time sitting here and focusing on the trial?
Yeah, kind of.
All right. So your jury service for the year is complete. You are excused. Thank you. $489. Any objection to 382 being stricken for cause?
No.
We skipped past 28. The clerk had, but that was the person that you all had previously agreed to excuse, correct? On juror 28, they were excused.
Yeah.
Okay. So we're at 49. I can't figure out how y'all have more people than I do, but we'll compare lists when we get done.
I went to Cypress Lake. I don't know. Where'd you go for Myers? Sure entrance.
All right. Come on. Good afternoon. Please be seated. Are you juror 489?
Yes.
All right. I'll allow the attorneys to begin their inquiry.
Good afternoon.
Good afternoon.
How are you today, sir?
Pretty good.
I'm Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state of Florida.
Okay.
Prior to coming to jury duty today, had you heard anything about this case?
I did. Yes, I did.
Okay. And where did you learn about this case?
It came up on my phone. I don't remember where.
All right. So just some kind of news source
That's it.
or notification. Now, in a trial, we depend on the evidence that jurors rely on to only come through this courtroom. We can't control what the news says or what's put out. Would you be able to set aside what you heard or saw in that notification and only rely on the evidence in this courtroom?
Yeah.
Okay. Now, the length of the trial is supposed to be about 2 to 3 weeks. We anticipate after this week another 2 weeks. Do you have anything in the next 2 weeks that will cause you hardship or the inability to be here?
Well, besides work, no. Yeah.
Where do you work?
Well, I run a screen printing and embroidery company.
Oh, okay. Is that
Of course.
in Cape Coral? All right. Is that something that you'd be able to still set aside for somewhat for 2 weeks to be able to sit on this jury? If you had
Not
to?
not without issues, but
Okay. Are they issues that would get in the way that you won't be able to focus on the trial?
not necessarily from here. I'm here, but you like to logistically get people to do things.
Sure. Okay. Now you heard that this case is different than most because the state is seeking the death penalty. Normally, after a verdict is reached, the jurors go home and they're done with their job, and the judge sentences. But because this is a death penalty case, the actual recommendation of the sentence will come from you and the other jurors. So you'll have 2 recommendations. The only 2 recommendations are life without parole. So life is life in Florida now. It means every day for the rest of their life. Or we have the death penalty, and you'll have to make one of those 2 recommendations. So after the first phase of the trial, if the jurors unanimously decide that the state has proven at least one count of first-degree premeditated murder, then you'll go to that penalty phase, which is a phase where you make that recommendation. And at the penalty phase, you'll hear evidence. The state will present evidence of what's called an aggravating factor, and we have to prove at least one aggravating factor beyond a reasonable doubt. If we prove a factor beyond a reasonable doubt to all the jurors, then you can consider everything you heard in the trial. You can consider anything the defense would choose to present through mitigating circumstances. And at the end of that process, you would make a recommendation. Now, do you have any personal or religious or moral opposition to the death penalty?
Well, I am Catholic, so
Sure.
naturally, if you follow the theology of
Sure.
the Catholic Church, then you are automatically opposed.
Right.
However, it's not really in my mind. It's not really me. I'm just following the rule of the state in the case, right?
Sure.
You just follow that. It wouldn't be me, it would be the state.
Right.
So regardless if I'm in the courtroom or not,
Right.
I'm still part of the state, right? So,
Right, exactly. So obviously, the Catholic religion is opposed to the death penalty.
Right.
But in this courtroom, the law guides a juror.
Right.
Now, some people would say, I because of my religion, I couldn't ask or recommend the death penalty, and that's a perfectly fine answer. Do you believe that you are that you could go against the Catholic faith and make that recommendation if the facts were such, or do you think that you would say, you know what, based on my my Catholic beliefs, I couldn't?
I believe I just would follow the rule
Okay.
of the state.
Sure.
And in my mind, it's not really me.
Right.
Recommending it, but the state, right? If you follow the rule, I'm not actually imposing anything.
Well, right. You're not. I mean, the judge ultimately still imposes a sentence, but the state has a burden to show the different aggravators. And at the end of the day, it is your decision what to recommend. So, there's law that will guide you. The judge will read the laws. You'll know exactly the process, how to do things. But you might have jurors that say, I don't think the facts and circumstances really do deserve the death penalty. And so they'll recommend life. And you might have jurors that say, every juror might say, we think the facts and circumstances deserve death. And there's not necessarily a right or wrong recommendation when it comes down to it at the end of the day, if the state's done its job and proven a factor. So you will have to, at the end of the day, make your own decision as to whether you think the death penalty is appropriate or not. Do you think that you would be able to hear the facts and circumstances and recommend death if you thought that legally that those facts and circumstances existed?
If after the trial, everything is presented and you hear everything and
Sure.
following the instruction and, whatever the law is,
Okay.
then if you had to make that determination, then you just make it.
Right. Okay. So you would feel like that's something you could do.
Like I said, I never been in these situations. So I couldn't tell you
Right.
what's going to happen, right?
Right. Absolutely.
But like I said, I think I'll be able to just follow all the rules and see what the instructions given to me is, and then looking at the law. And in my mind, I say, yeah, even though I'm Catholic, yeah, but it's just those are the rules that I didn't make, right?
Right. Obviously, there's a separation of church and state for a lot of people. And
Right. Well, yeah.
Okay. Well, I appreciate your thoughts, and obviously this is a process most people haven't been a part of, so it's hard to say what you would or wouldn't do. But it sounds like you're someone that can follow the law and can consider all the evidence. So I thank you very much.
Mr. Shirley.
Good afternoon.
Good afternoon.
My name is Kevin Shirley. My co-counsel is Lee Hollander, and we represent Mr. Wilson here today. Okay.
Sure.
Just a little bit of your background. I hear you have a slight accent.
Yes.
Where?
Not as light accent. I think it's pretty. You can say it. It's fine.
That's okay. My best friend's from Italy.
Yeah, I am from Italy.
You are from Italy. I don't know if they have this penalty in Italy.
No.
Okay.
No, they don't.
We're in the United States now, so you have to operate by our.
Right.
Okay. Do you understand in the state of Florida, when somebody is sentenced to life, that means life. We don't have parole anymore. You can't get out of prison anymore like you used to be able to. If you're sentenced to life, you serve every day of the rest of your life in prison. Do you understand?
Yes.
Do you think that's a pretty harsh penalty?
It really. I don't ever really thought about it, depending on the crime,
Right.
that you do. Then
But the person never gets to come out again. Okay.
if that's what the law says.
Okay.
That's what it is.
Okay.
As long as you know it before the crime, that's the penalty.
Well, let me skip a couple of steps that I've been doing here, and get closer to the heart of it. If you're a juror, you have to determine whether or not the state has proven an aggravating factor that this homicide rises to the level. You can't get death penalty in most homicide cases. You understand?
Yeah.
It has to be a special one.
Yes.
And the state has a way that they believe that they can prove that it's a special one. Okay.
Yep.
And if they do, then you have to determine whether or not there's anything that lessens the how severe a case this is,
Right.
because there may be some things that don't come out during the guilt phase or do come out during the guilt phase that you can't consider as to whether or not Mr. Wilson did this, but you might want to consider what kind of person Mr. Wilson is, or what made with Mr. Wilson the way he is now. Okay?
Yes.
You understand?
Yeah.
Now, some of those things might be something in Mr. Wilson's background, something that happened when he was a child, whether or not he has any mental health disorders, those types of things that you might want to consider, or something may have come out during the course of the trial that wasn't a defense to the charge, but it's something that you want to consider in determining whether or not this is the appropriate kind of penalty. Do you understand?
Yes.
Okay. Now, the most important thing, and we can't, you brought up your faith, and you were honest with us, and you told us, that's my faith, but that's just part of me, and I understand that there are rules in this state and rules in this country, and I need to follow them, but we can't ask you to ignore your faith either. that's going to be something in the background going through your head as you make your decision. And we can't tell you not to consider that, because that's one of the things that makes you the person that you are.
Right.
Okay. So what I'm asking, though, is whether or not you would use all of your life experiences, whether or not you look at the evidence in this case, and you would be able to make that decision as to whether or not Mr. Wilson deserves a recommendation of death, or whether or not you would recommend life.
Yeah, like I said before, I've never been in these situations. I would like to listen to whatever goes on in the trial, and then all the instruction again, and then you, like you say, you determine all the different things that come up. That could be something that alleviates, the circumstances, and then you make the decision. But like I said, I never.
But the point I'm trying to make, sir, is that it's an individual decision. It's something that you have to decide, and it's based upon your life experiences and what makes you different from everybody else. And that may, in fact, include some of your beliefs.
It may, yeah.
Okay. I don't have any further questions.
Okay.
Okay.
All right, sir. So remember my instructions. Don't do any research. Don't look up anything. Don't discuss anything about this case with anyone. Do you remember those instructions?
Yes.
Can you follow those instructions?
Sure.
Also, don't watch any local news media or read any local newspapers for the time being. Can you follow that instruction?
Yes.
All right. Then we will have you come back and join us tomorrow morning at 9 a.m. in the jury room on the second floor.
Second floor. Okay.
Okay. They'll show you out.
Good afternoon. How are you?
Well, thanks.
I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming in this morning, had you heard anything about this case?
I have not.
You know, you heard that the trial is expected to be 2 to 3 weeks. We anticipate another 2 weeks after this week is concluded. Do you have anything coming up that would cause a hardship for you to sit on this case?
No.
I'm going to ask you a little bit tougher question just about your opinions on the death penalty. Do you have any moral or personal or religious opposition to the death penalty?
I do not.
Now, a lot of people fall on one end of the spectrum, and then there's a lot of people that are somewhere in the middle. You have the people on one end that would say, regardless of what the murder is, that person should be put to death. You take a life, your life should be taken. And then you have people on the other side of that spectrum that would say we shouldn't have the death penalty at all, no matter what the circumstances, no matter who it was, we should never have it. And then you have people that are in the middle that would say it really depends on what the murder is. It depends on the facts, the circumstances, and they would want to hear it on a case-by-case basis to make that decision. Where would you say you fall when it comes to the death penalty?
Squarely in the middle.
Okay. And obviously, the decision to recommend death or life is a heavy one for anybody. It doesn't matter where you fall. It's a very difficult decision to make. Now, if we get, our plan is in this trial is our first phase is a guilt phase. And the state has a burden to prove the charges beyond a reasonable doubt, to call in witnesses, present evidence. And then if the jurors unanimously find that the state has proven at least one count of first-degree murder, then we go on to that penalty phase. And that penalty phase is where the jurors will actually make a recommendation as to the sentence. The state has only certain times it can seek the death penalty, and we have to actually allege aggravating factors, which are a part of the law, part of the statute. We've already alleged those factors, and we'll have to prove at least one of them beyond a reasonable doubt. If the jurors, again, unanimously find we've proven one, then you can consider those factors. You can consider the evidence. The defense has the opportunity at that hearing to present mitigation. They can present mitigating circumstances that would show why they don't believe their client should get the death sentence. And at the end of all that, it will be up to each juror to decide whether they will recommend death or life. And if the jurors have found the state proved an aggravating factor beyond a reasonable doubt, then every juror has their own choice regarding the sentence. There has to be at least 8 jurors to even make a recommendation of death. And then if there's not, then the recommendation is life. Now, if you felt the facts and circumstances rose to that level, do you think that you could sign your name and make a recommendation of death?
I do.
Okay, and then the opposite question, if you didn't feel that the state presented factors or circumstances that made you believe that it was enough for the death penalty, would you feel comfortable recommending life?
I do.
Now, the other situation that sometimes occurs is there may be 7 people that are in favor of recommending death. And so your decision of death would make that a recommendation. If you chose life, then the defendant would not get death. Do you think you could be that deciding vote and recommend death if the facts and circumstances warranted?
I do.
And then the opposite, if you had 7 recommending life and you believe that life was appropriate, could you make that recommendation?
Good.
All right. Thank you very much for your time.
All right, sure.
Just a few questions. Good afternoon. My name is Kevin Shirley. I, along with Lee Hollander, represent Mr. Wilson. Obviously, you've figured out that we're here on a first-degree murder case, and if you find the defendant not guilty or guilty of a lesser charge, we don't have to worry about all this penalty phase discussion. But this is in case there is a conviction. You understand?
I do.
And if somebody's convicted of first-degree murder, there's only 2 possible penalties. One is the death penalty, and the other is life in prison. Do you understand that?
I do.
Now, life in prison has changed in the state of Florida. Several years ago, they did away with a concept known as parole, where if you were a good guy in prison and you didn't get in trouble, then perhaps they would let you out early. We don't do that anymore. Now, if a jury recommends life and the judge sentences somebody to life, that's exactly where they stay. They're there every day for the rest of their for the rest of their lives. Do you understand that?
I do.
You think that's a pretty serious penalty?
Yeah, I do.
Okay. You understand that in most homicide cases, I'm not going to quote a percentage, but in most homicide cases, that is the sentence, is life. You're nodding your head.
Yes.
We have a microphone right there. You have to speak into it. Okay. So death is a penalty that's reserved only for the worst of the homicide cases. You understand that?
I do.
All right. And in order for the state to establish this as one of the worst homicide cases, they have to prove their aggravating factors beyond every reasonable doubt. That's the same burden of proof that they had initially in order to attempt to prove Mr. Wilson guilty of first-degree murder. And just because they prove him guilty of first-degree murder doesn't mean they get a free bite of the apple when it comes to sentencing. They have to convince you that it isn't just a homicide, it's an aggravated homicide, and here's why. And if they don't prove that to you beyond every reasonable doubt, then you've got a duty to return a recommendation of life. You understand that?
Yep.
Now, that stage of the proceeding is there's even more safeguards built in, because it's not just convincing you. They have to convince all 12 of you that there's at least one aggravating factor that they have proven beyond every reasonable doubt. If one juror gets up there and says, I don't think they proved it, then you guys are done, and it's a recommendation of life. Do you understand? And even though you might not like that, that's the law, and you'll follow it, will you not?
Will.
All right. If the jury decides as a whole that there's at least one aggravating factor out there, so it may be to the level where we would recommend death, but now you have to consider mitigating circumstances. I'm not going to tell you what those are. The judge may give you a list for you to consider. That isn't the only thing you can consider as a mitigating circumstance. You can consider something that you heard during the course of the trial. That, well, I didn't know that about this case. And even though the proofs rose to the level of a conviction, that thing that you heard during the course of the trial might be something that you stick in your back pocket and you consider as a mitigating circumstance later. Do you understand?
Yeah.
And there may be other things that you entertain. You might hear testimony from experts with regard to Mr. Wilson's mental health. Would you consider that testimony? Obviously, you have to weigh it to determine whether or not it's significant, to determine whether or not the testimony is credible, but would you at least consider it?
Of course.
And other things like information regarding perhaps Mr. Wilson's childhood, why he is the way that he is, and things like that. And you could consider all those as mitigating circumstances. And if you determine that those mitigating circumstances sufficiently eroded the aggravating factors and outweighed the aggravating factors, you could return a recommendation of life at that point, could you not?
Good.
All right. Lastly, if the jury feels that the aggravating factors still outweigh the mitigating circumstances, then you still have to make that individual decision whether or not you're that person that's going to recommend that the judge sentence Mr. Wilson to death. And you're going to have to make that decision on your own. The jury gets to vote as to how many of you feel the same way as you do, but nevertheless, that is solely your decision. You can't be intimidated into that decision or bullied into that decision. That decision is based on your life experiences and everything else that makes you the person that you are, and is not just the evidence that you heard or the arguments or the law. Do you understand?
I do.
You believe that you can make that decision?
I can.
I don't have further questions. Okay.
All right, sir. Remember my earlier instructions. Not to do any research, look up anything, discuss anything about this case with anyone. Remember those?
Sure.
All right, you can follow those instructions.
Sure.
Also, do not watch any local media, read any local newspapers, do any internet research or anything like that. If you get notifications on your phone, turn those off. Can you do that? All right. With that then, we'll have you come back and join us tomorrow morning at 9 a.m. Just meet in the jury room on the second floor. All right, thank you. Yes, I think now's a good time. All right, so we can bring down the other. They're already there. Let's just take a 10-minute recess. Let everybody stretch their legs. And are you juror 29?
Sir.
All right, then I'll allow the attorneys to begin their inquiry.
Good afternoon. I'm Sarah Miller, and this is Andreas Gardner, and we're both here on behalf of the state of Florida. Prior to coming in this morning, did you see on the news or hear anything about this case?
In the past, I have, yes.
Have you already formed an opinion, or do you believe you'd be able to set anything you've heard on the news aside? Let me word it differently first. Obviously, we have no control over what the news says or what they present or what facts come out or if they are even facts. And so it's the state's obligation to prove the charges that we've alleged beyond a reasonable doubt. And we can only do that through evidence in this courtroom. We have to call witnesses, we'll present evidence, and then the jurors will be asked to decide the case based only what they hear in the courtroom. Do you think that's something you can do, or would those outside sources influence your ability to do that?
I should be able to. I don't really watch the news, so I wouldn't really. It's like I said, it's something from the past that I've been told.
Okay, so you'd be able to set that aside and listen to the evidence in this courtroom.
Sure.
Now, as far as the length of the trial, we anticipate it'll be another 2 weeks after this week. Do you have anything coming up in the next several weeks that would cause you to be unable to sit on this jury?
My parents will be out of the country starting tomorrow for a week.
Okay.
I promised them I was going to take care of the house and their pets.
All right, and where do they live?
They live in the Cape.
Okay, so is that something that you could stay at their house and still come and do your jury duty during the day?
As long as I can go back to the house, yeah.
Okay. Now, as far as the death penalty is concerned, people have very strong opinions. People haven't really thought about it. Do you have a moral or religious or just personal opposition to the death penalty? That's a no. All right, she's typing everything down. Some people would say when it comes to the death penalty that they think that anybody should get the death penalty, that it doesn't matter who they murdered, what the facts and circumstances are, that they are deserving of death. Other people on the opposite end of that spectrum would say no one should get the death penalty. You've already indicated that's not you because you don't oppose it. And then there's the people in the middle that would say it really depends on the case, that just because someone's charged with murder doesn't automatically mean they should get the death penalty. I'd want to hear the facts and the circumstances and make my own decision about whether the death penalty is appropriate. Where would you say on that spectrum you fall?
I would say in the middle because I think that if it's self-defense, that's the only excuse for murder.
Okay. Now, the state, in order to even get to the penalty phase, the state has to prove the charges beyond a reasonable doubt. And the state has to prove at least one count of first-degree murder beyond a reasonable doubt. Now, we don't anticipate that you'll hear a self-defense. You may, but let's say that you find that the defendant's guilty of murder and that he was not acting in self-defense. Would you automatically say he deserves a death penalty? Or would you be able to sit and listen at the penalty phase? And so what happens, and I'll just give you a little explanation, what happens at the penalty phase is the state has another step that we have to meet. So we have a jury that's unanimously found him guilty of first-degree murder, meaning there wasn't a defense to the crime. And then they come to the penalty phase and the state has to prove at least an aggravator. So the law is very clear about when the state can seek the death penalty. It's not in every murder. In fact, it's not in most murders. There's very specific legal requirements the state has to meet in order to even seek the death penalty. So we have laid out aggravating factors that we believe we can prove beyond a reasonable doubt as to why we believe the defendant should get the death penalty. So you as jurors, if you get to that penalty phase, will listen to those aggravating factors. You'll listen to the evidence. You may rely on evidence you heard during the trial portion. And then the defense has the opportunity to present mitigating circumstances. They might present things such as childhood or present mental health, whatever they want to present to show that their client should not get the death penalty. And then if you as jurors find the state's proven one of those aggravating factors, each of you will get to decide whether to recommend death or life. At that point, we're going to ask that you've listened to all the evidence, you've considered everything, and are able to make a decision. Do you believe you'd be able to sit during that penalty phase and weigh all those factors and think about it all and make a decision?
Yes, I'm open to listening to the factors, but I will probably have my opinions towards the death penalty.
Okay. So do you think that based on your view that really any murder that's not self-defense should get the death penalty, do you think that that would impair your ability to listen to the evidence and make a recommendation independent of that view?
I guess it just depends on the circumstance.
Okay. So let me ask you, so we just have to be really clear so that we make sure we have a jury that can be fair and impartial and follow the law. And so the law requires you as a juror to listen to everything and to consider everything. Do you think that based on your view that, well, let me just make sure that I understand. Do you think that if there's not a self-defense claim, if self-defense is not met, do you think any first-degree murder should get the death penalty?
Yes.
Okay. Thank you very much.
Any questions? All right. Your jury service is complete for the year and you're excused. Thank you. 129. Any objection to 29 being stricken for cause?
No.
Okay. All right, please be seated. And are you juror 129?
Yes, sir.
All right, I will allow the attorneys to begin their inquiry.
Good afternoon.
Good afternoon.
I'm Sarah Miller, and this is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to coming in here today to serve as a juror, did you hear or see anything about this case?
Today, no.
Have you? Oh, go
I
ahead.
don't speak English very well.
All right. I appreciate you letting me know. Is Spanish your first language?
Yes.
Have there been things that maybe the judge has said that you haven't understood this morning due to your speaking Spanish as your first
Yeah.
language?
Mhm.
All right. Based on your limited understanding of certain words and terms, do you believe it would be difficult to sit in a trial and to pay attention given that there will be a lot of different words you may not be familiar with?
Yes.
And because of that, would you like to be excused from your jury
Yes.
service? All right. Thank you very much.
Thank you.
You want her to go in the room?
Okay, yes, you can go back to the room.
Okay. Sure.
And they'll tell you, just follow the bailiff. He's right there. All right, let the record reflect that the prospective juror 129 is outside the courtroom.
I'll wait for her to go first.
Well, she requested to be excused, but go ahead.
Judge, I believe that an excusal is appropriate, or we call it cause either way, but she's asked to be excused. She's indicated she does not understand numerous words in the English language and hasn't understood everything that you said. Based on that, I believe excusing her would be appropriate.
And we have the same standing objection simply because we believe that we should bring in an interpreter for the rest of the trial, and she could have an interpreter back in the jury room. I understand that's contrary to current case law. In order to preserve it for appeal, we're
Okay.
making our objection.
All right, seeing no authority for the defense position on that, and there is case law authority that the law instructs the court that interpreters for language interpreters are not permitted back in the jury room during deliberations, and that the prospective juror requested to be excused based on her language, her first language being Spanish and difficulty in understanding the English language. I will grant her excusal. She'll be excused. Statement spring right there. That's good right there. So you are excused. Your jury service is complete for the year, and that's all for today. Thank you. Okay, so then we have.
Thumbs up.
Well, if she comes back, then we know that she didn't understand what I said, but I have a feeling she understood that. 410. Right there behind the microphone, one seat over. There we go. All right, please be seated. All right, are you juror 410?
Sir.
All right, I'll let the attorneys begin their inquiry.
Thank you, Your Honor. Good afternoon. I'm Sarah Miller. This is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming into court today, did you see any news stories or know anything about this case?
It's kind of known for a long time. So.
I couldn't hear you. I'm sorry.
Yeah, sorry. Yes.
All right. And have you formed a fixed opinion about the defendant's guilt in this case based on what you've seen or heard?
Yes.
Right. And would you be able to put that opinion aside in listening to the evidence, or do you think your opinion is strong enough that you would have a hard time doing that?
It'd probably be strong enough that I couldn't.
Okay. Thank you very much.
No questions.
All right, thank you, sir. Your jury service is complete for the year. You're excused.
Phones.
207. Any objection to 410 being stricken for cause?
No.
And 29 also. Any objection to 29 being stricken for cause?
No.
Okay. 129. Your objection is noted. I wasn't trying to trick you. I just.
I think we're quite on the record.
Okay.
Juror entrance.
All right. Please be seated. Are you juror 207? All right. I'll allow the attorneys to begin their question.
Good afternoon. How are you today?
How are you?
Good, thank you. I'm Sarah Miller. This is Andreas Gardner, and we're both here on behalf of the state of Florida. Prior to coming in this morning, had you heard anything about this case?
No.
Now, you heard the judge say that this is going to be a 2 to 3 week trial. We anticipate it will be an additional 2 weeks after this one. Do you have anything coming up that's planned or that will cause a severe hardship in you serving as a juror?
I do have pre-planned trips.
And when is your pre-planned trip?
The 13th to the 18th, and then the 24th to the 21st of July.
And the pre-planned trips, have you had to book tickets for those? All right. And so if you were unable to go on those trips, would it affect your ability to sit here and listen to the evidence and to be fair and impartial in this case?
Yes.
All right. Thank you.
If you had to cancel those trips, would that cause a financial hardship for you?
Oh, no.
Okay. All right. Shirley, any questions? Or State, any more questions? Any more questions?
Judge, could we just approach for a moment?
Okay.
Concern. You heard that this case is unique in that we are seeking the death penalty. In most cases, we do not seek it. We're not even able to by law or statute. Now, do you have any moral or personal or religious opposition to the death penalty?
Yes, I am Catholic, and that's not something that we believe in.
Okay, so based on that, if you were chosen as a juror, you would not be able to make a recommendation of death. All right, thank you.
No question.
Okay. All right. Then your jury service is complete for the year. You are excused. All right. Sir, everybody please be seated. All right. Are you juror number 3?
I am.
All right. And then I'll allow the attorneys to begin their questions.
Good afternoon.
Afternoon.
I'm Sarah Miller. This is Andreas Gardner. We're both here on behalf of the state of Florida. Prior to coming into your jury selection or jury service today, did you know anything about this case?
No, ma'am.
Now, the judge mentioned that this is going to be a 2 to 3 week trial. We anticipate it'll be an additional 2 weeks after the week that we're currently in. Do you have any kind of hardship or any reason why you cannot serve for the next several weeks?
None in particular.
Now, you heard that this case is unusual and that the state is seeking the death penalty. In most jury trials, a verdict is announced and the jury goes home. But in this case, it will actually be up to the jury to make a recommendation of either death or life. Do you have any moral or personal or religious objections or opposition to the death penalty?
I don't know. It's up to me to say if someone lives or dies.
I'm going to have to ask you to speak up louder for me. I'm sorry.
I don't think I'm supposed to judge. As a Christian, I'm not supposed to judge people.
Okay.
I don't want to take any responsibility.
Right. So you're based on your Christian beliefs. You don't believe that you could sit in judgment and make the decision as to whether someone gets death or life.
I don't think it's up to me.
Okay. Now, in the state of Florida, the law does state that it is up to jurors to have to make that recommendation. So if the jury finds that the defendant is guilty beyond a reasonable doubt to at least the count of first-degree murder, then we do go to a penalty phase where the state has to prove certain factors. And so there are aggravating factors laid out by the law in the state of Florida. And the jurors have to make a finding whether the state proved at least one of those aggravating factors beyond a reasonable doubt. And if all the jurors agree to that, then we go to each individual juror being able to make a recommendation. And it either has to be a recommendation of life or death. Because of your Christian beliefs, do you believe that's something you would be unable to do to make a recommendation of life or death?
I don't think it should be up to me if someone.
I'm sorry, I didn't hear you.
I don't believe it should be up to me if someone lives or dies.
And so based on that, this probably is not the right jury for you. Would you agree with that?
I would hope so.
Thank you.
All right, sir. Your jury service for the year is complete. You're excused.
Thank you, Your Honor.
All right, 352.
Your entry.
Please be seated. And are you juror 352?
Yes.
All right, I'll allow the attorneys to begin the questions.
Good afternoon. Not evening yet, but I know it's been a long day. I'm Sarah Miller, and this is Andreas Gardner. We're here on behalf of the state. Thank you very much for your service. Now, prior to coming in this morning, had you heard anything about this case?
I have.
Okay, just from the news or social media?
On the news.
Now, the state's obligation is to prove the charges beyond a reasonable doubt, and we can only do that through evidence presented in this courtroom. We can't control what the media says or what they show or don't show, and so that's why we rely on jurors to only consider evidence presented in this courtroom. Do you believe that you'd be able to set aside what you may have seen or heard about this case and base your decision only on the evidence that's presented in this court?
Yes.
Now, you also heard that the trial is supposed to be 2 to 3 weeks. We anticipate an additional 2 weeks after this. Do you have any hardships or any reason why you would not be able to serve?
I do. I'm a single mom with 3 kids still living at home, and I'm an hourly employee.
Okay.
So even taking today off is rough on my paycheck. So
Sure. So would that create an extreme financial hardship for you to be here?
it would.
And it could actually cause you potentially to not
Well,
pay
I
the
just
bills?
wouldn't be able to pay my mortgage probably. The 3 weeks is
Big
a
deal.
lot of pay.
All right. Thank you very much.
Thank you.
All right. So your jury service for the year is complete. You are excused.
Oh, thank you so much.
All right, 67. How many do you all have now? Okay.
Yes, that's correct.
Entry. All right. Good afternoon. Please be seated. Are you juror 67?
And
All right. I'll allow the attorneys to begin their questions.
Good afternoon.
hi.
I'm Sarah Miller, and this is Andreas Gardner, and we're both here on behalf of the state of Florida. Prior to coming in for your jury duty today, had you heard anything about this case?
Yeah.
Okay. And where did you hear information?
It was on like main news, just being in the background.
Okay. Now, the state has the burden of proving the charges beyond a reasonable doubt. So in the first phase, the guilt phase of the trial, the state will have to bring in witnesses, present evidence, will show photographs, DNA, different forms of evidence to convince the jurors that the defendant is guilty beyond a reasonable doubt. And we can't control what the news says or doesn't say or whether they're factually accurate. And so that's why we rely on jurors to only base their verdict on the evidence in this courtroom. Do you think you'd be able to set aside what you may have heard or seen on the news and decide your verdict only on what you hear in the courtroom?
Yeah, would have some difficulty.
So do you believe, based on what you've already seen and heard, that you might have an opinion that could interfere with your ability to decide this case?
Yes.
Okay, thank you.
All right. Your jury service is complete for the year, and you're excused. Thank you. 234. Let's see. Any objections to 67, 352, and 3? Extreme for cause. All right, come back to it. All right, please be seated. And are you juror 234?
Yes.
All right, I'll allow the attorneys to begin their questions.
Good afternoon. How are you today?
Good. How are you?
Good, thank you. My name is Sarah Miller. This is Andreas Gardner, and we both represent the state of Florida. Prior to coming in this morning, had you heard anything about this case?
No.
Now, you heard the judge say that we anticipate this case to be 2 to 3 weeks. It'll probably be an additional 2 weeks after this. Do you have any hardships or anything coming up that would cause it to be difficult for you to serve?
I have a wisdom teeth removal next Friday.
Okay.
I mean, it's not like a necessary surgery, but it is scheduled.
Is that something you would be able to reschedule if you were selected as a juror?
Yes.
Now, you heard that this is a unique case that probably most people have never been a part of, and that's because it's a death penalty case. A death penalty case is different in that the jurors actually have a say in the sentence. And normally a jury gets to go home after the verdict. But in this case, if you and the other jurors unanimously find that the state has proven one count of first-degree premeditated murder beyond a reasonable doubt, you'll come back for a penalty phase. Do you have any religious or moral or personal opposition to the death penalty?
No.
Now, I would say, everybody has different opinions. Some people have very strong opinions one way or the other. Some people are more in the middle. So there's some people that will say everybody should get the death penalty. It doesn't matter who you killed. It doesn't matter the method. None of that matters. If you take a life should be taken. And then on the other end of that are people that are just completely opposed. That it doesn't matter who you kill, how many people you kill, how egregious the murder was. We shouldn't even have the death penalty. And then there's people that are really just more in the middle that would say it really depends on the case. I'd have to hear the facts. I'd have to hear the circumstances to be able to decide whether death is appropriate. Where do you fall on that spectrum?
Definitely probably in the middle. Not like I would have to hear about the case and the facts and everything before deciding.
Okay. And the state of Florida actually does not allow us to be on this side. We have to actually present evidence that supports a death penalty recommendation. And so the law actually lays out factors that the state has to prove. So if you get to that penalty phase, it will be our burden again to prove an aggravating factor beyond a reasonable doubt. And if all the jurors decide the state has proven that, then it will be up to you to recommend a sentence. And you'll be able to recommend a sentence based on everything you hear, based on what you hear in the trial phase, based on what you hear in the state's case. The defense also will have the opportunity at the penalty phase to present mitigating circumstances. So they can present anything from mental health, childhood, whatever they think would be appropriate to show the jurors why the defendant should not get the death penalty. But at the end of the day, it'll be you who will get to say, based on what I've heard, I think the death penalty is appropriate, or I don't think it's appropriate. Now, if you're able to sit and listen and hear everything, do you think if the facts rose to the level where the death penalty was appropriate, you would be able to actually make that recommendation to the judge?
No.
Okay. And just because it would be too big of a decision, or why? Just expand on that a little bit.
It would definitely be too big of a decision. Just, I guess now, like thinking about it more, like I don't think that the death penalty would be an appropriate decision for anyone to decide on something.
Okay. So even though the law in Florida does require a juror to make, it's just something that you personally would not feel comfortable doing.
Yeah.
And that's okay. And we appreciate that opinion. And that's what we want, is just to know it's a huge responsibility, a huge ask. And if you feel that this isn't the right case for you, then that's what we want to know. So thank you very much.
Can I have one question for
Sure.
Yeah. Good afternoon, I'm Kevin Shirley. I, together with Mr. Hollander, represent Mr. Wilson in the case. What we're trying to do is trying to make sure, and I'm not trying to talk you out of your position or anything like that. That's the way that you feel. That's what makes you the person that you are. Okay. I just want to make sure you say you're uncomfortable. Well, we would like to think that everybody would be uncomfortable about recommending the death penalty. I just want to make sure, are you telling us that you cannot envision a circumstance where you would recommend death as a possible penalty?
That's correct. I wouldn't.
I can't hear you. I'm sorry.
Sorry, that's correct. I wouldn't be able to do that.
Okay. All right. That's fair enough. I just want to make sure. Thank you.
Okay. Great. Okay. So your jury service for the year is complete. You are excused. $286. Oh, any objection to 234? I'm not sorry, 286. No,
This is 280.
Right, this case is 234, 267, I'm sorry, 67th, and never mind. All right, please be seated. Are you juror 286?
Yes.
All right, then I'll allow the attorneys to begin their questions.
Good afternoon.
Good afternoon.
If we counted right, you were the last person in the jury room.
No.
Oh,
There's
there's
one
another
more.
Okay, then I didn't count right. Thank you for your time and attention. I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Prior to coming in this morning, did you hear anything or see anything about this case?
Absolutely not.
Now, the judge mentioned that this is going to be a 2 to 3 week trial. We anticipate we're in week 1 right now, so another 2 weeks. Is there anything coming up in the next 2 weeks that will cause you hardship to sit here on this trial?
It depends on legally what is hardship to you guys. I run 3 businesses. I'm
Okay.
a mom of 2.
All right.
I work from home and my kids don't have daycare or anything like that. So I don't know.
All right. So let's go through that because there's all different reasons and hardships that can be excused. How old are your children?
8 and 11.
And are they in any kind of camps? Or are they home with you?
They're home with me.
And who's watching them today?
Grandparents that also work, but sometimes have time off.
So you would have difficulty even just with childcare alone. Is that accurate?
Possibly. Right now, our business is going through a hardship and I haven't been paid in 9 months.
Okay.
And so we have very low income coming into our house. So it'd be hard for me to pay for childcare.
Okay.
Yeah.
So, all right. So you would have an issue then getting childcare due to financial hardship.
Yes, ma'am.
And then just running 3 businesses and not being able to attend to those, you would believe that would be financial hardship as well.
Yes, ma'am.
And based on that, would you have a difficult time sitting here and giving your full attention to this case?
Absolutely.
Thank you very much.
All right. So your jury service is complete for the year and you're excused. Thank you. Okay. Before we call anybody else, wait. All right, let me get this down. So I'm just going back through. We had 410, 207, 3, 352, 67, 234, 286. Stricken for cause. Any objections?
No objection.
No objection.
Okay, thank you. All right. All right, please be seated. Good afternoon. Are you juror 70?
70.
Yes, 70.
Yes.
Okay, all right. Then I'll allow the attorneys to begin their questions.
Good afternoon.
Hello.
So you were the last person in the jury room, if I'm counting now correctly.
Yes.
All right. Well, it's all done by computer, so don't take any offense to the fact that you were last.
Okay.
I'm Sarah Miller. This is Andreas Gardner, and we're here on behalf of the state of Florida. Did you know anything about this case prior to coming to court today?
Yes.
Now, the state is obligated to prove the charges that we've alleged beyond a reasonable doubt, and we can only do that through evidence in this court. We have to call witnesses, present physical evidence, photographs, DNA, and we have to prove to the jurors beyond a reasonable doubt through the testimony alone from this courtroom. Do you believe that you, if you're selected as a juror, would be able to do that, or would you think about what you saw and what you heard and let that affect your verdict?
I've been watching it every night, so I'm probably affected by it.
All right. Do you believe that you have a fixed opinion about whether the defendant is guilty in this case?
Yes,
And so based on that, do you think you'd have a difficult time being fair and impartial then sitting here on this jury?
I do.
Thank you.
All right. Your jury service is complete for the year, ma'am, and you are excused. Thank you.
Thank you.
We have the next 10. Okay.
119.
All right. 119. Any objection to juror 70 being stricken for cause? Okay.
Your attention.
All right. Please be seated. Good afternoon. Are you juror 119?
Yes, I am.
All right. Then I'll allow the attorneys to begin their question.
Good afternoon. I'm Sarah Miller, and this is Andreas Gardner. We're here on behalf of the state of Florida. Prior to coming in for jury duty this morning, had you heard anything about this case?
Yes.
Now, the state has to prove the charges beyond a reasonable doubt, and we can only do that through evidence in this courtroom. We can't obviously control what the media says or whether it's factual or not. And so we need jurors that would be able to put aside what they've heard or seen and decide the case solely on the evidence from this courtroom. Is that something you think you can do based on what you've seen and heard?
Well, I lived in South Cape at the time of the incidents.
Okay.
And due to through my social connections going out and et cetera, there was a lot of conversation regarding various things. That was a while ago, but I still have to be upfront with that because I was socializing in that area, and I think I ran across a couple people that knew one of the girls. So not that it involved me, I didn't know anybody, but I just want to be clear about that.
No, I really appreciate that. Do you think because of those conversations you had and just knowing about the case for this long, that would affect your ability to be fair and impartial in this case as a juror?
Well, I'd like to think I could definitely be impartial, but given some of the details that I do recall were in conversation, whether they were true or not,
Sure.
hearsay,
Sure.
not sure.
All right. Thank you very much for your honesty.
All right. Your jury service for the year is complete. You are excused. Thank you. 4:45. Any objection to juror 119 being stricken for cause?
No.
Juror entry. All right, please be seated. Are you juror 445?
Yes, I am.
All right, good afternoon. I'll let the attorneys begin their questions.
Good afternoon.
Good afternoon.
Almost good evening.
Yes.
Sorry about that. This is a really important process and it does take a long time when we have to go through each individual juror, but we just want to make sure we get your opinions and hear what you have to say.
Of course.
My name is Sarah Miller. This is Andreas Gardner.
Hi.
And before you came in today, did you know anything about this case?
No.
Now, the judge mentioned that this is going to be a 2 to 3 week trial, probably an additional 2 weeks after this week. Do you have anything in the next 2 weeks that will cause you hardship if you had to sit here on this jury?
No, not at this time.
Now, you heard that this case is unusual. It's a case that most people have never been a part of, and that's because it's a death penalty case.
I'm going to speak up louder and lift your voice
Sure.
up.
That's because it's a death penalty case.
Yes.
So because of that, the jurors actually will have a say in what the penalty is. Typically, after a regular trial, the jury goes home after the verdict. But in this case, if the jury votes guilty and they vote that the state has proven the charge of first-degree premeditated murder beyond a reasonable doubt, then you'll come back for the penalty phase where you'll have to make a recommendation. Do you have any personal or religious or moral beliefs that make you opposed to the death penalty?
No, I don't. I really am very indifferent about it. I've never really thought about it.
All right. Okay. And that's a fair answer. A lot of people, some people are very passionate one way. They think everybody should get it. There's people passionate, think no one should get it. And then people just in the middle. But it sounds like you don't even necessarily know where you would stand because you haven't really thought about it. Is that
Right,
fair?
correct.
Okay. Now, the judge is going to guide the jurors along the way because it is somewhat of a complicated process. But at the penalty phase, the state will have to prove an aggravating factor. So the state of Florida makes it very clear when the state can actually seek the death penalty. And it's not in every homicide. It's only in homicides that meet certain requirements that are the most egregious and serious of homicides. If the state does choose to elect death, we have to give notice of aggravating factors that are listed by the statute as to what we intend to prove. So we've listed aggravating factors in this case, and you'll learn about those in the penalty phase. And it will be our obligation once again, and we'll have to prove at least one of those beyond a reasonable doubt. And if all the jurors unanimously find that we've proven one, then you'll get to think about all the evidence you have heard during the trial. The defense will have the option to present mitigating circumstances, whether they want to present mental health or childhood, the childhood the defendant have, whatever they want to present that they believe would be important for you to know in your consideration of death versus life. They're allowed to do that. And you'll sit and you'll listen to it all. And then at the end, you individually will each have to make your own recommendation. And that recommendation will be either death or life in prison. And life now in Florida is life. There's no parole or no getting out early. So it will be one of those two options. Do you think that you would be able to, if the state proves the aggravating factor, and if we're able to show you that this really is an egregious type case deserving of the death penalty, would you feel comfortable making that recommendation to the court and saying, you know, I'm going to sign my name. I believe that this is a case where the death penalty is deserved?
Yes.
Okay. And then on the flip side, if you hear the facts and maybe you hear some of the mitigators and you think, you know, this is a case that really just doesn't deserve the death penalty. It's really more of a case that deserves life. Do you believe you would be able to make that recommendation of life?
Yes.
All right. Now, you'll hear later on that in order to even recommend death, at least 8 jurors have to make that recommendation. So if you're back in the jury room and 7 people have committed and said, we recommend death, and you're the last person to vote, would you feel comfortable knowing that my vote is going to determine death or life?
I'd really have to think about that.
Okay. All right. Do you think you're someone that could stick by your beliefs and what you feel at the end in making your recommendations? Right. So you'd be able to, at the end, if you felt the death penalty was appropriate, to make that recommendation. And if you felt life was appropriate, you'd feel comfortable making that recommendation.
Right. I don't want to be pushed into my decision.
I'm sorry, what?
I don't want to be pushed into a decision by other people.
Right. So it sounds like you're an independent thinker, able to make your own decisions.
Yes.
All right, good. That's what we asked for, and I thank you very much for your time.
Mr. Shirley.
Good afternoon, ma'am.
Good afternoon.
My name's Kevin Shirley. I, along with co-counsel Lee Hollander, represent Mr. Wilson in this case.
Look.
Did you say you hadn't really ever thought about the death penalty before?
No, I mean, I believe in it if it's warranted, but I've never really thought about it. I mean, I'm not against it, but I'm not for it to just do it.
Okay, well, and I think that you understand by your comment that in cases of first-degree murder, obviously there's 2 sentences. The one sentence is life in prison where he never comes out again. You understand that?
Right.
And the other is the death penalty. You understand that?
Yes.
And very rarely do we seek the death penalty on homicide cases. They're left out there for the very, very special cases. You understand?
Yes.
So very seldom would a jury be called upon to make that decision. This particular case, if you're selected as a juror, you would be put in that position if you find the defendant guilty of either one of the homicides. Do you understand?
Yes.
Now, in order for it to rise to the level of one of those special types of homicides, and the state alluded to this a second ago, there are aggravating factors. Let's say you have returned a verdict of guilty on at least one of the homicide counts. Okay, so you have a guilty verdict. So normally the person would be sentenced to life, except in this particular case, the state is seeking to elevate that. So elevate the penalty because of aggravating factors. Do you understand that?
Yes.
Now, the judge would tell you what those aggravating factors are. You don't know that ahead of time. You're not going to really know what to look for ahead of time. You have to focus on the guilt phase, and once we hit the penalty phase, the judge will tell you what you need to look for. Okay?
Yes.
Or not what you need to look for, what you can look for.
Yeah.
Okay? And if the state does not prove those aggravating factors that bring it up to the level of the death penalty, then you return a recommendation of life in prison. Okay?
Yes.
You can do that.
Yes.
However, if they do show at least one aggravating factor beyond every reasonable doubt, then you would have to go on and consider, as the state has told you, mitigating circumstances. Now, those mitigating circumstances could be 5 things, it could be 100 things. Who knows, until it comes down to your consideration and our argument to you and the evidence that you're going to view. Do you understand?
Yes.
It might be something that you heard during the trial, where even though it didn't help the defendant in his defense during the trial, it helps the defendant at sentencing for your consideration on sentencing. Do you understand?
Yes.
So if it's brought out to you at a later point in time, you could consider something that you heard during the trial in the case. Do you understand that?
Yes.
Now, as the state alluded to, we can also provide you additional evidence. My client does not have to testify. He doesn't have to stand there, get up on the stand, and try and convince you not to recommend that the judge sentence him to death. The presumption of innocence stays with him throughout the whole trial. You understand that?
Yes.
Now, if we elect to put on some testimony, we would have to show that testimony is competent evidence and should be considered by you only by a greater weight of the evidence. State's burden on aggravating factors beyond every reasonable doubt. Our burden with regard to mitigating circumstances is a preponderance of the evidence. Do you understand?
Yes.
Or a greater weight of the evidence.
Yes.
Now, if you're convinced that the mitigating circumstances outweigh the aggravators, then in that case, you would turn around and you would recommend to the judge that the judge sentence Mr. Wilson to life in prison, because the aggravators have basically been beat down by the mitigators. So the thing that raised it to the level of consideration for the death penalty isn't there anymore. Do you understand?
Yes.
Now, in order to do that, you're going to have to go back there and you're going to have to make a personal decision. The jury as a whole is going to get together. They're going to vote. They're going to poll each juror, and each juror is going to say, I think the mitigating circumstances outweigh the aggravators. I can't vote for death. I have to vote for life. And each one of you is going to have to go through that procedure. And in the state of Florida, it would take 8 people to find that the aggravators outweigh the mitigators, and there's nothing in their personal lives that would prevent them from recommending death. So it takes 8 out of 12. You understand that?
Yes.
And it could be 7-4, and you could be the deciding vote. You understand that?
Yes.
So it's in your lap. It's not really in your lap because the others have already made their decision. But unfortunately, you get to make the deciding decision. Do you think you're capable of doing that?
Yes.
Okay. I don't have any further questions.
No, Judge.
Yeah.
All right. So you remember my instructions about not doing any research, looking up anything, discussing anything about this case with anyone, watching local news, reading local newspapers, not to do any of those things. Remember those instructions?
I do.
Can you follow those instructions?
I can.
Then we'll have you rejoin us tomorrow morning at 9 a.m. in the jury room down on the 2nd floor,
So where I started.
the main jury room where you started. If you'll meet us there at 9 o'clock tomorrow morning.
Okay. Thank you.
Thank you.